All right, this is cause number 1830854. And sir, you're Juan Sanchez?
Yes.
And so we're here today on a motion to compel. And before we get into a whole lot, I've done a lot of my own research and looking at all of this. And a couple of things.
Wow. Right from the start, you can feel the tension in the room. This isn't just paperwork. This is about access to information that could make or break one's probation. And right there, the judge lays out the rules in a way that's clear but kind of intimidating. Subpoena duces tecum, not the right tool. Already you feel the weight of the law bearing down.
Believe the subpoena duces tecum was the proper way to try to get the information. Duces tecum is an order to get somebody to bring something to a set hearing. So we didn't have a set hearing, and they weren't ordered to give it to at a set time for a hearing. So under the rules that have to do with subpoena duces tecum, I don't know that that was the proper way. I do think you're entitled to some of that information as a defense attorney. If we're going to base decisions on, if I'm going to base decisions on things that probation have in their file and that they're just going to tell us, I do believe that you are entitled to some of that information. I think the proper way to do it would be to make that request through the district attorney's office for discovery. And then for you, Mr. Nichols, to make those requests. And then I would approve you guys giving whatever records are requested within reason. If you have, I don't know what would necessarily be any type of work product that would not be discoverable, but if you think that there's something that is particularly not discoverable, let Mr. Nichols know that. Mr. Nichols let me know that. Then we could worry about maybe a motion to compel and whether or not I think those things are or are not.
Here's where it gets tricky. The defense is pushing hard for records. They want everything to ensure one's chances of staying on probation. But you can almost see the tension rising as the judge explains the proper channels. You start thinking, okay, so it's not just what you ask for, it's how you ask for it. That subtlety could make or break a case.
Well, let him finish, yes.
He did subpoena Wharton County records, so a representative from probation down there came in today for this hearing. I have no problem with getting him all that stuff. A lot of it's not in my possession. The out-of-county offense reports and things like that, I don't have yet. I would have them if we move towards a hearing where I prove up those allegations, and they, of course, will be provided beforehand. And again, I don't think he's not entitled to have all that stuff. So
Sure.
And then you have the probation officer laying out the detailed logs, appointments, drug tests, all of it. For someone watching this, it's easy to get lost in the legal jargon. But at its core, this is someone's life on the line. Every missed payment, every test, every check-in could affect their freedom. You can feel the stakes here.
Mr. Wong, or do you have any concerns you want to
If there's
make the court aware of?
Your Honor, just with the clarification of our departmental chronologicals, which include anything that pertains to the case that happens with chrono telephone calls, auto-generated appointments, reminders, office visits, drug tests, anything that we enter into the system. But those are the chronologicals through the probation office, as well as releasing of the jail logs, his sex offender verification, interlock reports, because those were not listed on the subpoena, as well as the offense report through DPS, which was released to me.
Now, this is raw. You can literally feel the frustration from the defense. He's arguing for access he's constitutionally entitled to. But the judge stays calm, de-escalates, and teaches a lesson. Being argumentative won't help your client. That moment, gold for anyone trying to understand not just law, but human behavior under pressure.
So let's do that. Y'all sit down. I want everything that you have that is, I don't know that there's anything I can think of that would be,
Unless, I guess
Not
notes may be work product, but I'm not real.
that's what I'm thinking about, but it's not really attorney's notes, and so I don't know that that would
I
be
would
an
object to
issue.
that, Your Honor, on the grounds that it's not attorney work product. It is merely work product of an employee, and it is discoverable and relevant to the case.
And that's what I just said. You seem very frustrated, and I'm not sure why. I don't know.
I'm confused by if there's pushback at all on any request for a 3914 discovery when he's constitutionally allowed to access those files. It should just be produced by.
Finally, the judge lays out a clear path. Mr. Nichols gets the files, they go into the portal, and everyone knows exactly what's in discovery. It's procedural, yes, but it's also justice in action. You can see the system working slow, deliberate, and sometimes frustrating, but working. And for Juan, it's a lifeline. This clarity could directly impact whether he stays on probation or not.
This is not something that a lot of attorneys have done in our cases. And so if there is something, if you'll sit around and watch today how everybody gets along, hold on.
Yes,
and the last thing you want to do is talk over me.
Yes, Your Honor.
So I'm standing here or sitting here saying that I agree with you, and you're still being argumentative, even towards me. And that's not going to get you anywhere. Hold on. Being argumentative with Mr. Nichols isn't going to help Mr. Sanchez. Being argumentative with these ladies isn't going to get you anywhere. I agree that you're entitled to this information. I just think there's a better, less argumentative, defensive way to do it. They were told to do what they were told to do, because their understanding of the law is what it is. So I don't disagree that we needed to all get together, but it just needs to be taken down a notch.
Watching this, you realize that court isn't just about the law on paper. It's about people, rights, and sometimes patience. Every tense exchange, every procedural fight, every moment of clarity tells a story. And the stakes? Real. Lives are affected. And that's what makes cases like this gripping, intense, and honestly a little heartbreaking.
So I want the stuff turned over to Mr. Nichols, and then Mr. Nichols will turn it over as discovery. I'm not going to have probation start turning it over to the individual attorneys in cases, because I think the proper way to make sure it's in the portal, that everybody knows what the discovery is that they've received, so that it's electronic when you sign your any type of documentation, whether it's at a hearing or a plea or a trial, of what you've discovered, that it goes through that portal so everybody knows what everybody's got. So y'all get it to Mr. Nichols. Mr. Nichols will put it in the portal, and then you will get it. Once you get that, if there's something that you think is not there, then contact us. We'll have a hearing if necessary. Contact Mr. Nichols. Hey, what about this? If it exists and he says no, then let's have a hearing about it. Okay? So y'all get that done, and then we'll reset the case for just an announcement in a couple weeks or so. Fine with that?
That should be fine, Judge. We'll be able to get everything scanned in and provided through the portal.
Perfect. Thank you. All right. Y'all are all excused.
You needed?
I'm sorry. No, ma'am. If you'll just get what you need to Mr. Nichols, unless you are personally subpoenaed to be here for a hearing. Now, and on that date, we won't have a hearing on that date. So if we come in and there's pleas of not true, and we're going to have a hearing, we can come in on that date, enter pleas of not true or true to certain allegations. Then we would reset it for a court date. And at that point, if you need to be here, let her know. If you need a subpoena, then you can get a subpoena. If you just need us to let you know you need to be here, then we can do it informally. You just let us know, or let Mr. Franklin or Mr. Nichols know what your employer will require for you to be here for an actual hearing. Okay?